Hello everybody. Welcome back to our CMA classes. This is Soumya Santosh, a CMA finalist. Today we are going to start the new chapter of our corporate and economic law, and the topic is going to be the Securitization and Reconstruction of Financial Asset and Enforcement of Security Interest Act 2002, which is known as SARFASI. Okay, so let's get started. So first of all, we have to understand why is this done. Okay, I'm not going to start from the very first section here. I'll continue definitely in the another lecture of this chapter, but right now I've started from section 13. Okay, so let me give a very basic thing why it is done. Okay, let's take example. Mr. X, okay, he had borrowed a money from Mr. Y. Okay, Mr. X borrowed a money, which means he is going to be borrower. Okay, what is going to be Mr. Y here? Mr. Y is going to be secured creditor. Okay, so Mr. Y have given loan or money or whatever. Okay, let's take that. On what basis? Either Mr. X have given some, security or something. He have kept something to Mr. Y, right? So what if Mr. X, the borrower, is unable to pay his debt? Okay, on due time. Okay, if he is unable to pay that due, okay, and if that continuation of unable to paying that due continues for 90 days, okay, once it cross 90 days, okay, in that case Mr. Y, the secured creditor, can take the measures, okay, but not now. Okay, once this 90 days is done, right, the due is not paid within that 90 days. After that completion of 90 days, Mr. Y, the secured creditor, is going to give notice to Mr. X, who is the borrower. Okay, so up to this everything is clear now. Okay, take it. If no reply is given within that 60 days of that notice given by Mr. Y, okay, in that case Mr. Y can take the measures. Okay, so I have given a very simple example to understand what is written in this section. So let's get started by section 13, which is enforcement of security interest. Okay, so in this case no intervention of court is going to be happen, which means court is not going to interfere in this case. Okay, so the intervention of court or tribunal enforcement of security interest is not going to happen in this case. Okay, in securitization of interest, security enforcement of security of interest. Okay, so notice, as I told you, Mr. X, Mr. Y, okay, after completion of that 90 days, Mr. X haven't paid any due to Mr. Y. Okay, in that case Y can issue notice, but only after completion of that 90 days. And what is going to happen? The asset, the security is going to be what? NPA, right? We know this. Okay, I'm not going in depth now. So that is non-performing asset, right? So in this case the notice is issued, okay, and the written notice is issued by whom? By the creditor, the secured creditor, Mr. Y. Okay, so the notice is issued by whom? By the secured creditor. To whom? To the borrower, to Mr. X. Now this is Mr. Y, okay, and this is Mr. X, okay, to discharge the liability within further 60 days. Okay, if it is done, then no measure is going to be taken. Okay, but what if the due is not paid within that 60 days? Okay, once the borrower make any default in repayment of secured debt, okay, or any installment, account of such borrower, we know this, account of that borrower is going to be what? Non-performing asset, is declared by as non-performing asset by whom? The secured creditor. We know this well. Okay, ji. Let's go for the other point written here. Notice shall state amount payable by the borrower and the full liability payable within 60 days from the date of issue of that notice. Okay, secured creditor to consider the representation or objection of the borrower. Okay, in this case we know this all thing. Okay, the borrower have fully right to make a representation. Okay, so yes, once the representation or objection is done by Mr. X, the borrower, in that case the secured creditor have to consider that representation or objection raised by the borrower. Okay, ji haan ji. Up to this everything is clear na? Yes, let's go for the other things written. Once notice is served on the borrower by the secured creditor, the borrower is entitled to make a representation or raise his objection, right? Yes. If secured creditor comes to conclusion that such representation or objection is not acceptable, he shall within 15 days communicate to borrower the reason for non-acceptance of representation or objection. Okay, hope so this point is also clear. Okay, there was Mr. X, there was Mr. Y, borrower, secured creditor, okay, he have not paid the debt, dues, installment, okay, and 90 days, from that 90 days he not cleared that any of the debt or installment, what is going to happen? The non-performing, the account is going to be what? Non-performing asset, okay, declared by whom? The yes, secured creditor, okay, and then the secured creditor is going to raise a notice, a written notice, not the oral one. We are not going to consider oral notice here, okay. So the written notice is going to be given by whom? The secured creditor to the borrower. इतना ठीक है? जी हाँ, बिल्कुल clear है. Okay, so in that case within 60 days the borrower have to pay the amount, the due, the debts, the installment, the remaining amount payable by whom? The borrowers, okay, borrower. And what if definitely he is having one right that he can oppose, okay, or he can he can raise a representation, okay, and that representation is to be considered by the secured creditor. And what if he is not considered that representation? In that case the secured creditor have to communicate this within next 15 days to the borrower that we are not going to consider this representation of yours with full reason, okay. So up to this everything is clear now. Okay, but what if nothing is given by, no debt is given by, again once the notice is given by a secured creditor, no debt or installment is paid by the borrower, okay, then the measures is going to be taken by whom? The secured creditor. So what could be the measures? Guess, jaldi guess, I'll tell you, okay. So asset, the secured creditor can take the charge of asset, okay, and can appoint some person, okay, or like secured creditor, administrator and all, directors, any superior person, okay, and vacate the person who was actually in that office, okay, who is having the superior person. And there are so many things, so we are going to discuss the measures now, okay. So measures for secured creditor in case of default by the borrower. When borrower fails to discharge his liability in full within 60 days from the date of notice, in that case some of the measures are going to be taken by the secured creditor, and that is going to be first take possession, okay, then take over of the management, then they can appoint any of the person or they can take asset charge, okay. So take possession, they are going to take the possession of that even lease asset, they have given the asset for lease, okay. So either they can take the possession, okay, or take over of the management, appoint any of the person, okay, and last was charge the asset. So these are the 4 measures taken by secured creditors. So there is one section saying few of the exemptions. So I have taken 2 exceptions here, okay. As per section 31, the provision of the act shall not going to be applied such cases as are covered, okay, where the amount is less than 20% of the principal amount and interest. In that case this is not going to be happen, the measure is not going to be taken by whom? By the secured creditor, okay. If the total remaining amount, the total remaining amount is less than 20% of what? The principal amount and the interest, in that case no measure is going to be happen. What this part is written in which section? Section 31, okay. We were reading section 13 and now the exceptions, few of the exceptions are written in section 31, okay, and I have only taken 2 here, okay, we will read it later, don't worry. And second, any secured interest created in agricultural land. So this section is again saying the provision of the act shall not apply in such cases as covered. I have given 2 examples. First, if the amount the remaining amount, the remaining debt is less than 20% of principal and interest, in that case this section is not going to be happen. ठीक है, okay जी, not going to be applied. Second, about the agriculture, ठीक है, agriculture land, any secure interest created which in related to agricultural land. Okay, so let's go for section 14, which says chief metropolitan magistrate or district magistrate to assist secured creditor in taking possession of secured asset. Secured creditor request chief metropolitan magistrate and district magistrate in written, okay, for the purpose of taking over the possession or control of the secured asset of the borrower. Okay, so affidavit pass suitable order for the purpose of taking possession of secured asset within next period of 30 days from the date of application. Further extension period of 60 days is granted. So they are going to request whom? They are under section 14. They are going to request, the secured creditor is going to request the chief metropolitan magistrate and district magistrate, any of them. Okay, so for taking the possession of the secured asset of the borrower. Okay, so this was all about the section 14. Let's go for section 15, the manner and effect of takeover of the management. So you have to tell me what is going to be the effect. As I told you, they are going to, there were 4 measures now. Okay, there were one thing written that they can appoint the any person, right? So in this case, let me give a few example, few things which is written in the section, which says the consequences of takeover of management by secured creditor. Okay, they can either appoint any of the person or administrator, okay, directors and all. Okay, and the consequence is going to be happen if there was any contract between directors and the management, that contract is going to be terminated. Okay, ठीक है जी, and the directors and superior power, superintendent's power, the person who is having some power or position in the company, they have to vacate the office. Okay, and no any of the resolution can be passed without they cannot pass the resolution. This is one of the point, and they cannot go for the liquidation, winding up procedure. Okay, so these are the consequences the company cannot take, the management cannot take the main decision by themselves. Okay, they have to concern the person which were appointed by secured creditors. Okay, so let's go for this section. Section 15 says about the manner and effect of takeover of the management. Publication of notice in newspaper with respect to takeover of management. When the management of business of borrower is taken over by whom? By the secured creditor. The secured creditor may appoint as many as it thinks fit. First, to be the director in case of borrower in the company. So either they can appoint directors in case of borrower of the company, okay, and to be the administrator of the business of borrower in any other cases. So director or administrator. ठीक है, hope so this was clear. They can appoint them. Okay, and what is going to be the consequences of publication of this notice? All the person holding office as director of the company, all the person having power of superintendent direction, second, ठीक है, and control shall deem to have vacate their office. So can I say the person who are having the superintendent power and the director of existing, ठीक है, we are not talking about जो जिनको अभी अपन ने appoint किए, ठीक है, we are not talking about the person who were appointed by secured creditor, okay, after this takeover of management. So the existing director, we are talking about the existing director, okay, existing director and superintendent directors and the person who are having power, ठीक है, they have to vacate the office. ठीक है जी, हाँ जी. Let's go for the second part. Any contract of management between whom? Between the borrower and director of management shall be terminated. ठीक है जी, हाँ जी, बहुत easy था ना. Okay जी. So first thing says कि director, superintendent, they have to vacate the office first of all. Okay, if any of the contract was between the director and management of the company, in that case that contract is going to be terminated. Okay, hope so this is clear na. हाँ जी, हाँ जी. All the properties of the business of borrower shall be deemed to be in custody of directors or administrator appointed by the secured creditor. So all the properties of the borrower is going to be taken over by whom? The person who were appointed by the secured creditor. Okay, so that is going to be in custody of them. that person. Which person? Director or administrator? ठीक है ना, हाँ जी ठीक है. So fourth point says about the directors or administrator appointed by secured creditor shall take all steps as may take necessary to take into custody all the property to which the business or the borrower is entitled. Last, the director or administrator appointed by secured creditor shall alone be entitled to exercise all the power of the business of the borrower. Okay, so these are the things which is written, the consequences of this section, section 15. Okay, certain right of shareholder suspend in case of takeover of the management. The shareholder of the company or the other person cannot nominate. Yes, in this section there is one more thing, that the shareholder of the company cannot appoint or nominate any of the person, okay, as director of the company. Okay, so as they are not having any right with them. Okay, so who is going to have the right in this case? As the person who were appointed by the secured creditors, right, the directors or the administrator. Okay, so they are the ultimate person who can appoint any person, or they will decide whether this person shall continue or not. Okay, but other than them, no person can have the right to appoint any person or to nominate any person even. Okay, so no resolution passed at meeting of shareholder of such company shall give effect to the unless it is approved by secured creditor. Okay, if it is approved by secured creditor, in that case the resolution is going to be validate, otherwise it's not going to be validate. ठीक है, हाँ जी. So let's go for the section 16 says about the no compensation to director for loss of office. अच्छा, do you remember we have read something in director वाला chapter कि compensation of loss, right? 202 something था ना section, right? So there was compensation given to whom? The directors and all. Okay, so I mean you know the section well, so you have to tell me in this case the directors, the person, the superintendent person who are having the power, right, they'll get compensation or not? Think about it. Nine. So in this case there is not going to be compensation given to the directors or the any other person. Okay, so no manager, director, no any other director, no manager, any person in charge of management of the person of the borrower. Okay, so don't mess up between that section and this section. Okay, so they are not entitled to any compensation for loss of office or premature termination under this act of the any contract or management entitled into by him with the borrower. Okay, so in this case section 16 says that they will not get the compensation. Whom? The managing director, the manager and the director. ठीक है जी, हाँ जी. Let's go for section 17, application against measure to recover secured debt. Any person aggrieved by any measure taken by the secured creditor may make an application to debt, DEBT, Debt Recovery Tribunal. Okay, so can I say DRT? Within how much days? Within 45 days from the date of such measures has been taken. Okay, so once the measure, okay, they cannot go or no, as I told you, no court or no tribunal can interfere in this case. Okay, but if once the measure is taken by the secured creditor, in that case they can definitely appeal for DRT, that is Debt Recovery Tribunal. Within how much days? Within next 45 days from date of such measure has been taken by the secured creditor. ठीक है जी, हाँ जी. So what is going to be the time limit for the disposal of the application? Any application made to Debt Recovery Tribunal shall be disposed of by within 60 days. Further extension time period of 60 days is extended. Total period of pendency of application shall not exceed 4 months. So can I say the order from whom? The DRT, Debt Recovery Tribunal, should be disposed within 60 days. Further 60 days can be granted, not more than 4 months. Okay, so that's it. This was in the section written in section 17. Okay, for how much days was there in this case? 45 days. Okay, so let's go for the section 18, which says appeal to appellate tribunal. So any person agree by the order of Debt Recovery Tribunal under section कौन सा? 17, right? So any person agree by the order of DRT under section कौन सा? Under section 17. So may prefer an appeal to whom? Appellate tribunal within 30 days. Earlier it was 45 days now, so now it's 30 days. Okay, so can I write? Yes, it's 30 days from the date of receipt of order of debt recovery tribunal. Is it clear? Yes, but in this case they have to deposit some money. Okay, but in case of DRT they have, I mean there would be some fees amount, but in this case they have to they have to deposit the 50% of amount. Okay, so 50% deposition of 50% of amount before filing appeal. The borrower shall deposit 50% of amount to the appellate tribunal. Okay, amount due from the borrower is claimed by the secured credit determined by the debt recovery tribunal, whichever is less, but it cannot be reduced by 25% of the total amount. Okay, so as I told you, in this case section 18 says if any of the person agree by the order of whom DRT, they can come here 80. ठीक है, appellate tribunal within कितना days? Within 30 days from the order of DRT. Okay, so but in this case they have to deposit the 50% of the amount. Okay, 50% of the amount, that is huge, that damn sure that huge, but they have to. Okay, but there is one relief that if the appellate tribunal think that the amount can be reduced, then definitely they can do so. Whichever the amount is lower, they have to deposit, but the amount could not be reduced by 25% of the amount. Okay, so this is what written in this case. Let's go for section 18b, which says appeal to the High Court in certain cases. Any borrower residing in the state of Jammu and Kashmir and agreed by the order made by District Judge under section 17A may prefer an appeal within 30 days from the date of receipt of order of this District Judge. ठीक है, so the same thing is written in this case. This section is for whom? The person who is residing in the state of Jammu and Kashmir. Okay, same thing is written. Okay, same thing is written. Okay, so how much days from within appeal can be made? Within 30 days from the order of District Judge. ठीक है जी, हाँ जी. 50% of amount is to be deposited. Yes जी. Not less than 25% of deposit amount is to be deposited. ठीक है, so yes, that's it. ठीक है, hope so this was clear to you. If it was, what you have to do, hit a like button, subscribe my channel and share this video to those who are doing CA, CS, CMA. ठीक है, and one more thing, sorry dear, I was really busy with some, I mean I was busy from past few weeks, so I was not consistent. I was very inconsistent, but we have to cover our remaining portion of tax and corporate law and all. ठीक है ना, I think so we have around 30 to 40% remaining portion of law, right, and 40% of, I guess, DT. Okay, so I'll be consistent, I promise, but for that you have to motivate me also. Okay, so we'll meet in our next video. तब तक के लिए पढ़ते रहो, खुश रहो, जिंदा रहो, ठीक है, और मस्त रहो, और कुछ नहीं. This is Soumya Santosh. We'll meet in our next video. Toodles guys.